Yeah, and just real quick, I want to say something just real quick. Just sorry, just 2 seconds because I'm all right. Thank you. I'm working on a case right now that relates to this, a previous case where I want everyone to be aware of this. If you're a young person that has a company that's sponsoring you in the lottery, if you're an old person and you're in India and you're having someone sponsor you in the lottery, maybe you didn't just graduate from school. Everyone across the board, I want everyone to take away this from this conversation. If you take away anything, take away this. You cannot pay your H-1B fees. That is a violation of the law. If your company agrees to sponsor you and turns around and says, hey, you need to pay us for your H-1B that was selected in the lottery, you cannot do this. It is illegal. And if USCIS ever finds out about it, or CBP when you're coming in, or the consulate when you apply for a visa, they will consider it a material misrepresentation. They will claim that you got that job because of money, not because you qualified for the position. I have unfortunately over the past 3 months learned that there are a number of companies who present themselves as U.S. employers who will sponsor people's visas. And if the case is selected in the lottery, they turn around and say, hey, you need to pay consulting fees for your selected case. You need to pay these fees, and in return, we'll file your H-1B. You cannot pay H-1B filing fees. You cannot pay the attorney fees for the case. The petitioner, who is the employer, is responsible for those fees. And the problem with U.S. immigration is the petitioner puts the beneficiary over a barrel and says, you got a once-in-a-lifetime opportunity. Your H-1B case was picked in the lottery. You have an opportunity to get an approval and come work in the United States, probably make a lot more money than you make right now. But we don't want to pay for any of this, so we want you to pay for it. You can't do that. So I just wanted to express that right now because sorry, again, my nose. I literally have a case right now that I'm working on for a person where that is what happened to that person. And that person got put into deferred inspection with CBP. They got their visa canceled and they got removed. The incident that happened to them years ago, 4, 5, 6 years ago. This incident had occurred, and they had subsequently been coming in, working on an H-1B, no problems. They weren't even with the employer that did this. However, CBP, through their methods, they're always allowed. They can look through your phone. They can look at your calls. They can look at your texts. They can look at your WhatsApp, your social media, your old resumes, anything. They were able to procure information that showed a handshake agreement for payment in return for services. Once they got that guy dead to rights on that, they had a fraud and misrepresentation finding and had him removed from the United States. He's been outside the United States now for almost 2 years, and we're still trying to find an avenue to get him back in. So I get it. I get it that it's tough to get picked in the lottery, but I think it's very important that people are aware that this practice is not legal.